some basic fundamentals behind or the thought process behind the mediations. Now, the mediation and conciliation is a non-adversarial procedure. It is a resolutionary procedure as against litigation and arbitration, which is adjudicatory, where the third person is adjudicating who's right, who's wrong, who should get what or who should not get what. Okay, in mediation, that's not happening. So the differences between the two, the role of neutral, as a mediator, my role is a facilitator. I'm not a deciding factor who decides for them. Parties decide for themselves. I hold their hands in order to reach that midpoint or consensus where both of them are happy about. Naturally, the process, like I said, I hold their hands. I'm not whipping their back. Okay, so the process is very, very friendly. It's not a very officially daunting procedure. It's a very friendly procedure where the parties can be at ease while going through the process. And this other differences, the subtle differences, what we call in litigations, in court cases, everything is based upon what happened in the past at the point of time when that particular incident occurred, right? उसने वो वक्त क्या किया, उसके लिए क्या proof है, etc. So everything is about the past, what happened. While in mediation, we believe what is done is done. We need to move ahead in life now. So we look at the future. What is it the parties expect from the future rather than getting their positions anchored to the past. And that's something very important for everybody to learn, right? As a general life lesson, we really need to look at the future rather than being anchored about the past. And as a result, in court cases, in judicial litigations, it's all about rights. Who has a right to something or whose right is better than the others will win the court case. While in mediation, we do not talk of rights. Maybe somebody is more entitled, but that does not matter. What matters is interest, how best the interests of the parties can be served. All right. So I will give a few examples maybe that will help everybody understand these things better. So disputes maybe that will help everybody understand these things better. So disputes suitable for mediation. What are the disputes suitable for mediation? Typically commercial disputes, partnership between the two partners, family disputes, workplace disputes, personal injury matters, or industrial disputes. These are some of the disputes which are really suitable for mediation, but otherwise any dispute can go for mediation and be heard by mediation. Why I have categorized these as suitable for mediation is because these are the situations where the two quarreling parties or warring parties would want to maintain their relations even in future, right? Suppose partnership. If there is a partnership firm, there is a dispute between the two partners and say one goes to the court of law, the case drags on for 10 years, the verdict is in favor of one of the partners. So that partner feels, okay, he has won the case. The other person is going to be very sore that he has lost the case. And under that situation, can you expect the partnership firm to continue to work or for them to stay together and work? Very, very unlikely, right? Instead, if that dispute is resolved within a couple of days and amicably, then they can continue to work ahead. Like we say, the relationship between the parties is maintained. So also the family matters. We don't want to cut off a family member because there is a dispute, right? We would want to solve the dispute and yet maintain the relation with that person. And that's why these disputes become suitable for mediation. But having said that, any dispute, absolutely any dispute can go for mediation and be settled.
हमें उम्मीद है कि आपको यह वीडियो अच्छा लगा। हम बहुत रेगुलरली मनी मैटर्स, हेल्थ और एंटरटेनमेंट पर सीनियर सिटीजन्स के लिए एक्सक्लूसिव वीडियोस रिलीज करते हैं। यदि आप हमारे नए वीडियोस को मिस नहीं करना चाहते तो नीचे दिए गए सब्सक्राइब बटन पर क्लिक करें।